Thank you, Madam Speaker. To the bill.
To the bill.
At its core, House Bill 2014 is a protection for survivors. It seeks to right the wrongs of the 2016 Horton Supreme Court decision, which placed an arbitrary one-size-fits-all cap on non-economic damages. It will reestablish the protections victims in Oregon had between 1999 and 2016. The current non-economic damages cap limits juries' authority. The cap means our state's most vulnerable victims may recover far less than the damages a jury has decided they deserve. This is particularly harmful when the economic damages a victim receives are minimal, despite the fact that they will deal with significant consequences for the rest of their lives. So that we're clear on the terminology, economic damages are lost wages, medical bills, and future medical needs, not economic damages, on the other hand, compensate survivors for the dramatic changes to their quality of life, lingering trauma, lifelong physical pain, the loss of a limb, or permanent paralysis. With House Bill 2014, we acknowledge that both economic and non-economic damages matter to survivors. A senior who was abused or neglected in a nursing home doesn't have lost wages. A child who is sexually abused likely does not have large medical bills. But survivors in both these situations are left with a lifetime's worth of mental anguish and trauma. The victims who are awarded these damages are generally private citizens with limited resources. So the current damages cap is essentially a protection for the powerful against marginalized victims. Victims must prove non-economic damages in a court of law, so there are significant checks on frivolous suits and outrageous payouts. The civil justice system is designed to make victims whole and compensate them for the negligence of others. House Bill 2014 helps make the intent a reality. Insurance policies, whether medical malpractice policies, motor vehicle policies, or others, don't cover intentional acts. Insurance also doesn't cover sexual abuse in any situation. While an individual can be held accountable for their intentional acts throughout the criminal justice system, our civil justice system is there to hold the institutions, organizations, and individuals accountable for their recklessness and negligence. I'd like to share one story that particularly resonated with me. Betty Rotting was 73 years old when she was sexually abused by a paramedic while in an ambulance on her way to get heart surgery. When Betty brought a civil case on behalf of herself and 5 other victims, it was discovered that the company had failed to address the numerous prior complaints against that paramedic. The actions of the paramedic were criminal. The actions of the company were negligent. And Betty's civil case helped uncover the truth. Lifting the cap on non-economic damages will allow other victims to be justly compensated and expose negligence that has led to a lifetime of anguish, particularly when the victim has suffered from a crime that does not lend to economic damages. As a police officer, I was also the first person to interact with someone who experienced trauma. I have seen firsthand how much impact these experiences can have on someone's life. Victims deserve to have their day in court and have a jury of their peers decide the justice they are due. I believe it is one of our most fundamental constitutional rights as Oregonians and as Americans. Thank you for your time and attention, and I hope you will join me in supporting House Bill 2014. I would, Madam Speaker. Colleagues, today I believe we have a chance to protect survivors by lifting the cap on the non-economic damages they suffer. While a number of my colleagues have addressed why we believe this bill is necessary, I would like to address some concerns about House Bill 2014. excuse me, those who view the threat of rate increases as a reason to maintain the current cap worry that rural providers and small clinic providers will be priced out, or that emerging graduates will choose not to practice in Oregon because the risk is too high. To those who say that lifting the cap will increase insurance rates, I point to states like Florida, Ohio, Oklahoma, Nevada, where malpractice rates have increased by double-digit margins despite their arbitrary caps on non-economic damages. Recently, an appeals court in Wisconsin ruled that the state's compensation cap hadn't lowered health care costs or improved care. There are numerous factors that play into malpractice rates. Caps are only one of those factors, and the data on their impact is inconclusive. Oregonians' right to a jury trial shouldn't be balanced against inconclusive data. What we do know is that medical liability insurance accounts for just 2% of the total health care costs, and there are many, many factors that may determine insurance rates. An increase in lower-level claims may adversely affect rates more than a single rare large claim. We want to ensure access to health care for all Oregonians, rural and urban, and have voted several times in this chamber to do this this session. Colleagues, it is important to remember that this bill is not about physicians and their clinics. It's about supporting victims. It is about child abuse, employer neglect, and the other forms of abuses that a jury determines deserves a financial remedy. This bill is about the right to a jury verdict. This bill is about victims' right to a jury verdict and to their rights to be made whole. House Bill 2014 is about protecting survivors. Colleagues, I urge your aye vote.